Kelsey, who's actually joining us, I think, live in Select Committee 4.
Yes, I actually came down here to speak face-to-face to the committee, so it is rather disappointing. Kia ora te committee. I have made an extensive submission. It is the fourth time I have made a submission on this bill. I invite, in the rather derisory 5 minutes allocated to me, the committee to reflect on your constitutional responsibilities as you are asked to provide a veneer of legitimacy to ACT's bankrupt bill, a bill already rejected 3 times by the Parliament, and that ACT seeks to bypass similar scrutiny through a backdoor coalition deal this time. David Seymour has made it very clear that he will only listen to those who agree with him, continuing his disdain for democratic processes and for evidence-based policy advice, including from his own officials. My challenge today is to National and New Zealand First for pandering to ACT's ideological fetish yet again in allowing this bill to get this far, and in having committed, unlike the Treaty Principles Bill, to see it into legislation based on the proposals from ACT in the past. And I really invite you to think of what that means for what you say you as parties believe in. We have heard in the Waitangi Tribunal and from submitters already before the Select Committee that this is yet another denigration of Te Tiriti o Waitangi, and I echo that, but I want to focus on 2 other matters that have not been so well canvassed. Earlier, we heard concerns that the bill will vest unaccountable executive power in the Minister of Regulation. And I want to talk to that at the same time as the problems with the Minister being able to hand-pick the Regulatory Standards Board comprised of private individuals. Let me be very clear that from my own experience, David Seymour does not give a toss about transparency, accountability, and good governance. In my submission, I set out a 6-month attempt to get documents under the Official Information Act. Only when the Ombudsman intervened did we get repeatedly, oops, I'm sorry, I forgot about that one. And then again, oops, I'm sorry, I forgot about that one too. My sincere apologies. And then yet again, oh, I'm sorry, I didn't actually realize that the Act applied to verbal decisions as information. And therefore, I've made some handwritten, totally illegible comments on the documents that I've sent to you. Now, I don't actually care whether David Seymour is woefully ignorant of the Act or showed contemptuous disregard for the Act. What he has shown is that he is not someone who can or should be trusted with any executive power, let alone what is proposed in this bill. As Bill Rosenberg has said in his submission, this is compounded by the fact that the proposed board would be an instrument of the minister. The minister can appoint who he wants, sack any members that step out of line immediately without giving any reason. And you can bet, and again, this is based on research, that he will continue the pattern of appointing fellow travellers of ACT, as he did, or as ACT did, with the Regulatory Responsibility Task Force, supposedly having an independent chair, but had Graham Scott as the chair. And when I did an OIA on who was consulted in the drafting of this bill, lo and behold, he consulted Bryce Wilkinson, Graham Scott, with some legal advice from Jack Hodder. These are the people who we will see the minister appointing to the board. And are we going to really accept these unelected ideological partisans are those who should be passing judgment on proposed and existing legislation with
Jane,
the potential to paralyse the regulatory process through a deluge of reviews.
I'm sorry to interrupt you, but we are coming close to full time. If you've got
I
some
do
concluding
not
comments.
want to have questions. I want to finish my submission.
We're at 5 minutes
Go on,
now,
here
so if you
go.
could please make some concluding comments.
This is just, as you will have seen from the letter that was the open letter, such a farce. In my submission, I talk about the issues about regulatory takings, about the consequences that there will be not only in terms of the chilling effect of the potential compensation that will be sought, for example, if National seeks to pursue its introduction of competition in the area of supermarkets and banks and electricity companies, but where you will end up having to make a decision about whether you're going to confess your non-compliance with the principles of this bill, pay massive compensation, or abandon your policies. I pointed out in detail the consequences of a potential investor-state dispute settlement, something that both successive recent governments have said that they do not support because of its legal and fiscal risks. And so I say to the committee, and in particular National and New Zealand First, you have the ability and responsibility to stop this bill now. We have seen the consequences of light-handed regulation in the past. That was a light version of this. Give us Pike River, give us the finance company collapses, give us the leaky buildings, of which I'm currently paying $180,000 to get my one apartment fixed. You have the ability and responsibility to stop this now, and history will judge you very harshly if you fail to do so. Kia ora.
Kia ora. Thank you, Jane. All right. In your hands, Ganesh, we've got you for 5 minutes, but as you would have seen, if you can leave a minute or two for questions, that's helpful.
I'll try. E ngā iwi, e ngā mana, e ngā reo, e rā rangatira mā. Tēnā koutou katoa. Ko Ganesh, Ahirao toko ingoa. I'm a first-generation New Zealander born in Aotearoa. For the record, I am neither deranged nor a bot. I am proudly tangata Treaty. I stand alongside tangata whenua and strongly urge members of this committee to heed the findings and recommendations of the Waitangi Tribunal contained in their interim urgent report on this bill. I have a PhD in economics from Victoria University Te Herenga Waka, and so I now turn to the economics underpinning this bill. Property rights and power are at the very heart of economics and of this bill. Rightly, there is robust argument and debate over points of contention and substance. I do not resile from that. But using privileged power positions to insult, denigrate, and belittle people and their communities is not robust debate. This committee and the House must consider its responsibilities in the protection of the rights of all to contribute and participate in a safe and constructive democratic process. And that lies at the very core of this bill. Responsibilities and property and rights and economic power. Just whose rights and whose property and whose economic power are to be protected by this bill and whose by omission are to be ignored. And where do responsibilities lie? For I refer to Clause 8 of this bill and the so-called principles of responsible regulation. I note the parallel with the principles of responsible fiscal management now embedded in the Public Finance Act. I ask, what makes such principles responsible? Principles have been applied, but the responsibility of the ensuing fiscal management remains moot. In a similar vein, Clause 8 of this bill contains principles, but whether they are responsible or not remains moot. Notably, there are no criteria provided against which the responsibility or not of such principles can be assessed. Bluntly, to suggest a set of principles are responsible purely because they have been stated as such requires logic involving some spectacularly breathtaking circularity. So the responsibility or not of the principles which underpin this bill falls at the very first hurdle. Thereafter, I infer from the stated principles that responsibility revolves around the rights of property owners, irrespective of any obligations associated with the possession of such property. Additionally, there is no consideration of how such rights and property were acquired in the first place. Hence, I infer that existing property rights of individuals take primacy. Rights relating to collectively owned and operated property are starkly omitted and seemingly irrelevant. And consideration and rights and property of future generations are similarly absent, as are obligations to such future generations. Critically, I am forced to construct these inferences as there is no statement of assumptions. Alternatively, there is no statement of the economic model and the inherent assumptions required to ensure that these principles would indeed be responsible. And as any good economic student should know, the transparency of assumptions is central in the framing of the model through which the economic argument is made. But the assumptions are not transparent in this bill. Further, the economic model consistent with the inferred assumptions may have been relevant to a 17th century view of the world. However, the economic model is wholly and totally inappropriate for a 21st century Aotearoa, where collectively owned and operated property and kaitiaki and guardianship obligations to future generations are central to many communities. If this were submitted as a stage 1 economics paper, it would struggle to get a D grade. The economic case for this bill is at best flimsy. It fails the test of transparency. Its assumptions are not transparent. It fails the test of relevancy. Its economic model is not relevant. And it fails the test of responsibility, for there are no criteria with which to assess its assertions of responsibility. Therefore, alongside the clear findings and recommendations of the Waitangi Tribunal, I submit there is a solemn, compelling, and indeed overwhelming case that this bill be discarded in its entirety.
Thank you, Ganesh. Right on time.